Okay, let me know when the camera's up now.
Yeah, you're going.
See, it kind of works out. So, I did the U.S. first 40 barrels and 20 kegs. This is about when the U.S. Department of Agriculture specifically went after Coca-Cola and seized their 40 barrels and 20 kegs of Coca-Cola syrup because they failed to adhere to the Pure Food and Drug Act. My thesis is the case of the U.S. first 40 barrels and 20 kegs of Coca-Cola of Atlanta, Georgia, was essential in both the exposure of flaws within the Pure Food and Drug Act of 1906, as well as the eventual action taken on by the Supreme Court to define the terms within it, which rendered the law useful in the legal system. During that time, and the reason they came up with the Pure Food and Drug Act, along with over 200 other bills that went through Congress within the 25 years surrounding it, was the patent medicine, prescribed medications, industrialism, and violence. The industrialism was a lot of immigrants and also families were mobilizing to cities. They weren't sanitary. Food wasn't grown nearby anymore. It was getting shipped in from state to state. And there wasn't anything to keep it preserved other than ice. And eventually a lot of chemicals that were often considered poisonous were added to the food to preserve it. And then there was violence, mostly due to the two first reasons. The patent medicines are medications that you could buy anywhere from a festival to the street to a pharmacy. And even the prescribed medicines were usually causing problems. The soldiers away at war were on a lot of morphine. They would come back addicted and treat their morphine addiction with cocaine. Cocaine was also used for a lot of other things. If you had a headache, if your child had a toothache, give them a little fun little drop, it would feel better. Some chloroform, in case you had a little cough. I know all of you have little allergies. You could use this. That would be really helpful. The morphine was really helpful, especially with little kids that maybe cried or made noise or didn't feel well. And that is just another example to help your throat. And there was also misbranding. So even if it wasn't something you actually took, I mean, they cured cancer, so that was good. However, Washington Wiley was the person that pushed the Pure Food and Drug Act and also pushed to go to court with Coca-Cola. He had a vendetta against caffeine and against pretty much like any food that was not really what it said it was. He discovered this ambition when he found honey that was not actually made of any honey. It was like molasses. And he started testing a lot of foods and found caffeine was one of the biggies. And also when they started prohibiting a lot of the things that you saw previously, most of them were just replaced with caffeine. So he didn't want to just redo everything. He was in the Department of Agriculture, which was created when he was put ahead of it. He was the chief chemist at the Bureau of Chemistry, and he created the Poison Squad, which was 10 men who ate food that was poisoned with all the things that were in all the food they were eating anyway. Or with things that just get into it that might not be poison, but like, you know, debris, animals. He's a big activist against caffeine. This was a draft of the bill, which was extremely big, and also the jungle came out and really grossed people out, which kind of took their attention away from the dangerous drugs and recreational things they were using and went to their daily consumption of food and drinks, and they were pretty upset about it. When they took Coca-Cola to court, Coca-Cola was also going to court for a lot of other things, either right before or during. They sued the IRS for over $10,000, saying they were not a medication, lied about having cocaine in their beverage, and would often bring anyone to court that might be utilizing their name or their marketing or pretty much anything that had anything to do with them, which kind of gave them a bad reputation in court with a lot of the judges. One judge said their hands weren't clean and that they built their company on lies, addiction, and fraud. The charges that they were charged with were misbranding. The images on the label were Coca and Cola, which the Coca is the plant where the cocaine comes from, and Cola is the cola nut, which is where the caffeine comes from. They also were charged with adulteration due to the poisonous substances, and they were also engaging in interstate commerce, which was what activated them breaking the law in the first place. The first time they went to court was 2 years later, and they had Sanford, who ruled in favor of Coca-Cola because of how awful the law was and how it was written so poorly that it could not be utilized in any court system, that it didn't make sense, the words did not have definitions, and frankly it wasn't his job to give them definitions. The next time they went to court was 2 years later. Wiley had retired, well, he'd quit immediately after the first court case and started promoting from media. The next time they went to court, they went and had Judge Dennison for appeals. He was even more angry than the first time they went to court and told them how angry he was throughout the entire case. He wanted to know why caffeine was something that was added, and if it was added, then what was the base. They basically came to court not able to answer any of the questions that any courts had to ask them, and their entire law was useless and had no meaning or definition. They finally went to court in 1916 again to appeal for the third time, because even though all the judges were insulting everything that they'd done, they also showed that their anger was mostly based off the fact that they wanted to help people and they wanted the law to work. And they were really disappointed that the people that made the law had an opportunity to help the public and failed so epically. They finally went to court under Charles Hughes, and he was kind of over the whole Coca-Cola getting away with everything. So he ended up giving everything a definition, especially the word added, which was the biggest problem. And he also set precedent for Coca-Cola not being misbranded, but it wasn't due to the fact that their name was Coca-Cola or that they were a distinct brand name. It was due to the fact that they did in fact have coca leaves that supposedly did not have cocaine on them, and they had cola kernels. So technically, they were following the rules. He didn't want people to be able to name something arsenic, put some arsenic in it, and follow this rule, because basically the way this law was written entitled you to make really, really dangerous things for consumption under specific names, and you could sell it, but you didn't want to leave a precedent that drinks and food could merely put the name of something horrible in their name and then be able to put it in their beverage as well, and it would be legal. So he also said they were guilty of adding caffeine. The added meant that they would be adding something that wasn't already there, or adding something more than you might expect, or that might not be there naturally. He said that they would have to go to court and prove that caffeine was not a poisonous substance. Coca-Cola then wrote letters to the Department of Justice and the Department of Agriculture begging to go out of court. Agriculture said no and spent a year building up a tactic to prove that caffeine was dangerous. But while they were doing this, Coca-Cola was talking to the Department of Justice, lowering their caffeine content levels and labeling all their bottles, and also wrote to the Department of Justice that they would pay all the fees for both sides and pay for the seized material and for whatever their fines were. So they settled outside of court, but because they gave in to the Pure Food and Drug Act, they set an example for all the other companies that they had to follow with caffeine added substances labeling, and if not just because this company was, but for fear that they would also be dragged into court for 5 years. It also set an example of a judge taking power away from the legislation in Congress to say exactly what a law means, regardless of what another judge might think that it means.